called as previously announced, and the times will be as allotted to counsel. The first case today is 13-1061, United States v. Ishmael Vazquez.
Mr. Glickman.
Good morning, Your Honor. I would like to reserve 3 minutes of my 10 minutes for rebuttal, if that's possible.
You may have it.
Thank you. This is a case where my client was convicted of various drug conspiracy and drug charges and a firearms charge and was sentenced to life without parole. In reviewing the pleadings in this case, it's clear that my client did not receive a fair trial. The overwhelming evidence from the record is that there were violations of defendants' rights to a fair trial throughout the conduct of the trial, the closing, and in the sentencing. Starting with the closing, which is the most serious, I believe, violation. During the closing, the prosecution makes the statement that, in rebuttal, makes the statement that the government presented 3, 10, 15 witnesses. Every witness was witness against the defendant, and repeated that in various iterations throughout. This was an unconstitutional shifting of burden. Now, I
was able to find only one place in the record where the prosecutor said anything that was that looked to be possibly improper. He said at one point, "I submit to you that these witnesses were credible," something like that.
Right. He says that more than once.
Well, I only found it once, and but I'll look in the record. There was no objection to it.
There were very few objections throughout this trial, which is the basis of our ineffective claim. Most of the testimony that came in, most of the leading testimony, the impermissible hearsay testimony, the third level hearsay testimony, the non-conspiratorial statements, the excessive testimony about murders, all that came in without objection. The statement with the specific statement where he talks about in closing about, "I submit to you that this witness is telling the truth," and that goes to the key witness, Noelia Lopez Ortiz, who was the first witness.
Yeah, but then he followed that statement with listing the reasons why the jury should find the witness was credible.
He did, but including among those reasons were reasons which we think are impermissible, which were intentionally inflammatory, and inflammatory in a sense to deprive my client.
But again, without any objection.
Yes, as I said, there were very few objections.
And the statement, "I submit to you that this witness is telling the truth," although inartfully phrased, really is subject to two different interpretations, isn't it?
It could be, with the exception of you have to look at it in the context. And if you look at it,
but I am looking at it in the context. I'm looking at it with the fact that it's immediately followed by a recitation of the reasons why the jury should find the witness credible.
And among those reasons were that two, which I find are highly inflammatory and basically do not go to the question of truthfulness, but rather go to inflaming the jury. And those are, one is that Noelia Lopez Ortiz only had a third-grade education, was not educated, in effect saying, therefore, she could not make up a lie because she didn't have the education to do so. And the second, which came in, which I think is more than one time, is stated in closing, is that the defendant ruined Noelia's life, destroyed her life, ruined her life. That really doesn't go to, that's not part of the conspiracy, ruining Noelia's life. That's an extraneous statement solely designed to inflame the jury. And the reason that defendant allegedly ruined Noelia's life is that he killed her son, who was another drug dealer. And during the testimony that comes in, it's extremely graphic. It's extremely graphic testimony.
You mean the testimony about the murders?
About all the murders.
But the murder testimony was the subject of very careful triage by the district court. The government proffered, as I understand it, evidence of 6 or 7 murders. The district court said it wouldn't allow that, even without an objection. It did what amounted to a Rule 403 balancing, acknowledged that the murders were probative because they were in the course of the conspiracy and at the defendant's direction, according to the witnesses, and limited the government not only to 3 murders, but severely limited what the witnesses were able to say about those murders.
I think the court tried to limit what was said about the murders, but was fairly unsuccessful. And what's interesting is that, in fact, the judge, in effect, functioned as defense counsel, which repeatedly made objections that defense counsel should have made. Leading testimony, you're testifying. No, you can't say that when the judge, when the prosecution said that's my point.
But that's to the judge's credit. That may be material to your ineffective assistance counsel claim, but that claim's not properly before us.
Well, it's our submission that this is one of those rare instances where ineffective is on its face.
Do we know what was in defense counsel's mind when he didn't object?
Well, it's hard to posit.
We don't know whether these decisions were strategic or whether there was some kind of battle plan. I mean, that's the reason why in United States against Marlowe we adopted this rule that where these claims aren't raised below, that except in very unusual circumstances, we're going to require that they be brought in the district court by 2255 petitions.
I think this is one of those, but
why? Because we said the exception is where the record is developed. By that we mean where we can tell what the attorney's reasons were for doing what he did. We've got none of that in this record.
But there's no ostensible, credible reason for the defense counsel not to have objected in many of these instances, in most of these instances, and not to object in closing argument as to the confrontation clause issue, as to the I submit issue, as to Noelia's ruining on Noelia's life, and sentencing there was no objection, even though there was no. This court has repeatedly said that a judge needs to, in a conspiracy case, needs to do an individualized determination. There was none in this case. There was none at all. The PSR simply stated.
Counsel, you've reserved 3 minutes.
Good morning, Your Honor. Good morning, judges. May it please the court. Judge, addressing the appellant's first issue, which was the issue of government's rebuttal argument and the number of witnesses that were against the defendant as being an example of burden shifting. This comment by the government was directly related to the defense's comment in its closing argument, where it suggested that there were only 3 witnesses against the defendant, and that the jury could believe or not believe those, or the jury should not believe those 3 witnesses that were against the defendant. And
but even a statement that the jury, by the defense, that the jury shouldn't believe the witnesses doesn't open the door for the prosecutor to state his personal belief in the credibility of the witness.
I completely agree with you.
And the prosecutor did say, with respect to Noelia, I submit to you that this witness is telling the truth. Now, if that's a statement of the prosecutor's personal opinion, it's improper.
And once again, Judge, I do agree with you. But first, if I could address the issue of the number of witnesses, and then I will get to Noelia's statement. I was the prosecutor in the case, by the way, so I remember the statements that were made. But specifically on page 34 of the transcript, it does state there were 17, 18, et cetera, witnesses, and the response, this is the rebuttal argument, this was directly in response to a defense's suggestion that there were only 3 witnesses against the defendant. And that was the purpose of the government, of me stating that there were numerous witnesses. Now, whether the jury believed them or not, once again, in my both my closing and my rebuttal, I stated many times, it's your jury to determine the credibility. In fact, if you look at the transcript, I repeated that several times in both the closing and the rebuttal arguments. Jury,
Can we get back to the statement I find problematic?
Yes, sir.
All right. I mean, no one's asking you any questions about referring to the number of witnesses. If that was accurate or even approximately accurate, that's not a problem. All right. What is a problem is saying to the jury that you think that this witness is credible, if that's what you said.
Well, Judge, I disagree with appellant counsel's interpretation. I think that if you look at the record, first of all, I submit to the court that I submit too many times. And in fact, I believe the brief refers to, I used the word I submit to you 22 times in my closing argument. I think it's clearly that I was using that as a crutch. And it's clearly evident that that was a preface to what I was about to say. So the word I submit to you was merely a preface, a preamble, or maybe even a summary of the evidence that I just stated. It's clear that when I argued about Noelia, that I gave the reasons why I was submitting to them that she was truthful. Now, it wasn't me personally, Jose Masuko, submitting to the jury they should believe me. In fact, once again, I cite that the record is very clear. I made it clear to the jury that it wasn't what I said. It wasn't how many times I raised my hands. It wasn't how many times I pointed at the defendant's table. That should concern them. The record is clear that immediately after this and prior to this, I advised the jury that our statements in closing argument were just statements. They weren't evidence. And that the only evidence they were to concern themselves with was the evidence they heard from the witness stand. And more interesting was I even told the jurors, which appellant counsel thinks was improper, I told the jurors that if they didn't believe any of the witnesses, it was their duty to acquit the defendant. I invited the jurors in my closing and my rebuttal to acquit the defendant. And I, in fact, told them if they had reasonable doubt that they must acquit the defendant. So certainly, I was not concerned with what my opinion was when I used the words I submit. Once again,
had counsel objected to your using the term I submit to you that Noelia is telling the truth, what would you have done? We're here on plain error review, but suppose he had made an objection.
Once again, I still do not think, well, if he had objected, the standard would be different.
Well,
I understand.
you have an appellate court telling you I submit that a witness is credible is a problematic statement.
I think it does raise the eyebrow, does raise the legal eyebrow and makes but once again, I think the standard requires that you look in the entire context of the use of that statement. I think it's a close call, and I think if there had been an objection that it would be a different analysis, but once again, I think the conclusion would still be the same.
Why do you think it's a close call? I mean, Merriam-Webster defines submit as its first definition is to present or propose to another for review, consideration, or decision, which is exactly what you were doing. You were presenting to the jury for their review or consideration a proposition. That's what you do in closing, isn't it? Well,
I agree with you. I agree with you in that sense, but once again, I can see the appellant's argument that, hey, I am interjecting my personal opinion into the closing argument. I just don't think that the record itself substantiates that. I think it's clear that what I was trying to do with my poor use of the English language was emphasize to the jury the points that the United States felt that they should consider. It's one of those things. I'm no stranger to the fine art of imperfection, and I certainly, through doing these cases, I learned, what words are good and what words are not good to use. In fact, this court has told me what words are not good to use in closing arguments on occasion. What I suggest to the court, though, is that in this particular case, use of the word I submit was not intended to interject my personal opinion and therefore was not improper.
You don't have much time, and would you go to the objection that's been raised that there was no individualized drug quantity determination here?
Well, once again, I disagree with this in that I believe the evidence on the record clearly supported the amount of drugs that this conspiracy used.
No, but it's not a question of evidence on the record. It's a question of whether the court district court made any determination, not whether it could have made a determination, but whether it did so.
Once again, I will defer the argument in the brief on that, but I would suggest to the court that the court was...
Well, one argument in your brief is that that statement is in the PSR and that he did not object to the PSR, and therefore the judge was entitled to take that statement, which is an implicit attribution of individual amounts.
Well, and I believe that essentially, Your Honor, one, clearly there was no objection, but the PSR was taken directly from the record, and the record clearly laid out quantities of which the judge could make her individual findings.
But what did the pre-sentence report say? In other words, the defendant is telling us that the pre-sentence report did nothing more than make a conspiracy-wide drug quantity finding.
Well,
you say it made a drug quantity attribution that the district court could adopt. And I'm just confused as to which one of those was correct.
Well, Your Honor, and I agree, had this been, say, another member of the conspiracy, for example, a member who was a seller for a certain portion of time.
But could you just try to answer that question?
Yes, sir.
What was the language that the PSI report used?
I do not have the PSR in front of me, so once again, I apologize for that, but I can maybe answer your question by stating that this conspiracy was established. The defendant in this particular case, Ismael Vazquez, was the person who started the conspiracy and ended the conspiracy. So he was a member, he was the leader of the conspiracy for the entire time. It's not like somebody who was in there for an intermittent time, and so therefore you need to extrapolate 2 years as a drug seller for this person and 3 years as a runner or a courier. It wasn't that nature. In this case, in this unique circumstance, Ismael Vazquez-Larrauri was the founder of the conspiracy, and the conspiracy started and ended with him. Therefore, all of the drugs, he was the leader. So all of the drugs that were sold during the life of the conspiracy do apply to him because he was the conspiracy. I agree that it's different and distinguishable from other members of the conspiracy.
So your proposition is that when someone is in a leadership role in a conspiracy, there is no need for the district court to make an individualized drug quantity determination.
No, I disagree with that. I think that in this particular case, the witnesses established the amount of drugs, 1/2 of a kilogram of heroin per month, 1.5 kilograms of crack per month for the duration of the conspiracy. And we also broke it down at specific times. If you recall the testimony of Mr. Roig. Mr. Roig,
But you're saying, you keep going back to the underlying proof. But what you're saying is that because there was proof of how many drugs the conspiracy handled over a period of time, that there is no need for an individualized drug quantity determination.
Answer.
I think it could be interpreted that way, but I suggest to the court that by evaluating the testimony, you are answering the same question because it does make that calculation.
We would like a 28J letter from you within 1 week after our argument as to what exactly the PSR said on this point.
Thank you.
And if your opponent has a different view, he may also file a letter.
Thank you, Your Honor.
Your Honor, I have the PSR. And the PSR starts off by saying, according to the information made available by the U.S. Attorney's Office, there was no individualized review of the record in the PSR.
What's the language of the PSR?
At trial, it was proved, according to the U.S. information made available by the U.S. Attorney's Office, at trial it was proven that this drug trafficking organization involved over 1 kilogram of crack and heroin per month for over a period of over more than 4 years. Also, the defendant was responsible for at least 3 murders, and then the defendant was the leader of the organization since 1994. If only a 4-year span is taken as a sample, then the defendant would be responsible for at least 48 kilograms of crack and 48 kilograms of heroin.
All right. So it does have language that the defendant was responsible. That's individualized.
But that comes directly, that doesn't come from an analysis which is required by this court It comes
No,
directly
it
from
doesn't. Wait a minute. The rule of law, as I understand it, is that at sentencing, unobjected to statements of fact contained in a pre-sentence report are evidence that a district court may rely on at sentencing. And the district court adopted the findings in this pre-sentence report, and that finding, it seems to me, would include the statement you just read that the defendant was responsible for.
The problem with the findings in the PSR is that it wasn't made based upon the trial record. It was made based on what the U.S. Attorney's Office told them. And this court has said that when a district court evaluates a drug conspiracy, that it has to make the court has to make an individualized determination of the witnesses as to whether they've proven the amount as opposed to the existence of the conspiracy. And I just want to, very briefly, because I only have a minute left, is to go back to the statement that was made with regard to the vouching and the credibility on that. And if you take away the word submit, then in this sentence you have, and I ask you, was she telling the truth? I submit to you that she was. And you take away submit, you now have, and I ask you, was she telling the truth? She was. So the submit doesn't
No one is
really
suggesting taking away I submit. The suggestion is that I submit means I propose. And when you read that sentence substituting propose for submit, it doesn't seem to be vouching at all.
And then it goes on to explaining as to why that is. You've got to understand where she's coming from. She's a 59-year-old woman with a third-grade education who could barely sign her own name. She could barely sign her own name. And that's why she says the defendant destroyed her life.
But can't the prosecutor's got to be able to argue that the witnesses are credible.
He does, but
those
I argue that those don't go to credibility. The fact that she's a 59-year-old woman with a third-grade education doesn't go to her credibility.
Well, he's making the point that it's too complex a story for her to make up. Now, that's not convincing to me, but it's an argument.
And that she's telling the truth because the defendant destroyed her life. That doesn't make sense.
Well, then your client benefited from an incoherent argument by the prosecution.
But a very inflammatory one.
All right. Thank you.
Thank you.